This is ramondeleon with Smoothoperationoflaw. And as usual, I'm coming here to bring you some of this knowledge. I just want to say I appreciate everybody viewing the videos. Okay, we have been getting consistently, as of this point, over about 200 views for the last few videos. So I really appreciate you guys, and I encourage you guys to like, share, and subscribe as usual. Okay, I have a very, very special yet short evaluation of a topic today for everybody's consumption. So my biggest pet peeve when it comes to my channel is that I like to talk about intellectual property rights and its effects on any infringers, including state actors. Everybody always says in the Secured Party community that this is all about controlling the name. Well, how do you control the name? Everybody runs around and tells people to go get a DBA or go get a, common law copyright. And I always and consistently, because I know better, have the experience to tell you that common law copyright doesn't work. And trademark is the type of intellectual property right that allows for a waiver of sovereign immunity from state actors per their use. But today, I'm going to show you via one of the documents that I have that taught me a lot. I'm not going to go through the whole thing. It's pretty much a short book. And it goes through every legal avenue of approach for recovering with either a tort claim or some other format in regards to a state actor doing a violation or infringement of trademark law. I'm going to say it as I've always said it. Your name needs to be a trademark. And here is why. Washington and Lee Law Review. Remedies for the misappropriation of intellectual property by state and municipal governments before and after Seminole Tribe, the 11th Amendment, and other immunity doctrines. Now, before I get into this, I am just going to go give a short visual of the table of contents to this document. Introduction. Intellectual property and the takings clause. Is intellectual property Fifth Amendment property? When is infringement of intellectual property a Fifth Amendment taking? Remedial aspects of the Fifth Amendment. And that's pretty much what we're going to talk about in this video only. But as you look down in the document, it talks about protection beyond the takings clause. What is a state? Okay, Seminole Tribe and the revival of state sovereign immunity, City of Bourne and the abrogation statutes, the scope of congressional authority under Section 5 of the 14th Amendment. And then it talks about post-Seminole Tribe decisions. Does the subjective intent of Congress matter? The curious case of bankruptcy. Can state immunity be avoided by suing in state court? Suing officers and municipalities under Title 42, Section 1983, and then lawsuits against officials, official capacity and individual capacity lawsuits under color of law, state law, injunctive relief, official immunity, laws against local governments, conflicts between federal and state jurisdictions, Section 1983 litigation, lawsuits against governments, lawsuits against officers, lawsuits under the intellectual property statutes. Must the federal court defer to state proceedings? And now I'm going to give you just a summation, a brief summation, because like I said, we are only going to talk about chapter 1 of this topic. I'm not going to go into all the other stuff because if you would like that, go ahead into my private group, contact me so you can become a member, and then we can have open discussions. As I always tell you, it's not legal advice. I can't make this stuff up. It's out there. It's in PDFs. It's in books. So all I would do is just keep pointing back to the document. The thing is that the concoction of what I am pointing to is not an instrument that I am giving you. So with that being said, you will just take the knowledge. I could give you a copy. All this stuff could be found on the internet. And you, upon reading maybe what I might have shared with you, can make the decisive decision on your plan of approach to protecting your ass. That was a mouthful. All right, so here we go. Ultimately, the Fifth Amendment takings clause is as follows. Give it a sec. Public use is a legal requirement under the takings clause. Nor shall private property be taken for public use without just compensation of the Fifth Amendment of the Constitution, that owners of property seized by eminent domain for public use be paid just compensation. And what does that mean? That means they cannot take your shit for public use. If you have your name as a trademark and you are in a courtroom, they are using your name for public use. Now, whether or not they understand that it is a trademarked asset has absolutely nothing to do with their liabilities. If you would like to know more about that, go to Wikipedia and look up the definition of operation of law. And I've said it in a few videos. I'm going to just reiterate it in summation right now. What operational law means is that whether or not the intent of the party was to infringe or not infringe, after their act has been committed, they owe as a result of creating a right or liability, regardless of that intent. So if I were to be a lawyer or a prosecutor or a judge, and I were to go after an individual, and their name comes up, and it's on those public documents, and that name is a trademark, there is a whole new element not regarding the charges. So not regarding the charges, that the judge and the prosecutor has now created. You better enforce your trademark, because what happens is you incapacitate them from being judge and prosecutor. They are now defendants in a civil suit. And the reason why they can't run from it is because not only does Title 15, Section 1122 of the United States Code say that there's a waiver of sovereign immunity, as long as you are arguing only about the trademark and not about the issue at hand. Those guys will lose immunity. If you conflate the arguments and say, hey, judge, you can't give me a traffic ticket because my name is trademark, you're fucked. Forget the traffic ticket, argue just the name. And you will see that once you start to look at your name being intellectual property and you treat it as intellectual property, you will be able to apply federal statutes against said state, and you will be able to apply the constitutional violation of takings. Now, what does Title 15, Section 1122 say? Look at Section B for states, A for the federal government, and C will tell you your remedies once you pull it up. With that being said, yes, you can use a federal jurisdiction because of an immediate constitutional violations due to the takings clause. That is one of the biggest prongs in affecting your protection of your trademark. If you don't say shit, you're fucked. Now, can you do that with, again, as I've said in other videos, banking documents or anything of that nature? Well, not really, unless you have a trust. Unless your trust is irrevocable. Here's a cool video for you guys. I was talking to somebody in Australia, and I was talking to them about the power of the irrevocable trust, but how it should be appropriately set up. And not that I support the individual, not my friend, but not my compadre that I was talking to, but the individual I'm about to mention, he did this before he died. Who is this individual? Well, Jeffrey Epstein, and it's on Fox Business. You can put in Jeffrey Epstein Irrevocable Trust Fox Business right into YouTube, and you can see in pretty much a 5-minute little talk or whatever between the host of the show, this lady, and an expert, you can see they're talking about the composition of his irrevocable trust. Why did he create an irrevocable trust? Well, 2 days later, he supposedly died. Whether he did or did not, I'm not here to debate that. But before he died, he did an irrevocable trust with a pour-over will. And they explain in that Fox Business segment the shielding and nature of his construct of that trust. He put in a choice of law clause of the Virgin Islands. So that means his trust was constructed under the Virgin Islands. And what he did was he put a pour-over will. The irrevocable trust is a trust in which the grantor cannot take away or add to that indenture, and they no longer control said properties that were granted into that trust. That means if it was money or intellectual property, that's not my intellectual property. Now think about that. If it's not your intellectual property, then who's controlling it? Well, you could still be the grantor and the first trustee, as long as you have a second trustee and you're not named as the beneficiary, and you can check law merger for that. And then you can see what the construct of the trust must be. But here's the fact. If Jeffrey Epstein made the same type of trust I developed, and yes, of course, my trust would have a pour-over will, and it does. And it is also irrevocable. Then none of the assets that I have are mine under ownership. They belong to that trust. And because I can never take them back, per se, if not, it would be an alter ego. And someone else is receiving a benefit of said assets, because if not, it'd be an alter ego. Then that trust is viable. And the choice of law clause that I choose for that trust will control the jurisdiction of the trust. For example, I could be in Wyoming and choose New York State as my choice of law, and my trust would be governed under New York State rules. Period. And things like intellectual property are intangible. They're not physical assets like a car where, okay, well, it could be governed under New York, cool. But maybe if you move to another state and you're using it all the time and you're benefiting from it via its use right there, then and there in that moment, then maybe, you might be subject to the local laws because you're making minimum contacts with the state. But that's neither here nor there. The fact is intellectual property is intangible. So that means it's omnipotent. It can exist as far and wide as reaching as you would like. Think about it. You put it up on a business on the internet, you just expanded globally. So your trademark literally expanded into every cell phone and every computer on earth. It is literally interstate commerce the minute that it goes up on the internet. It is literally international. And all it is a symbol or mark for goods and services. So you put those property rights inside of that trust, and what happens? Even if you had a gun on you that you weren't supposed to have, your second trustee can question the court about the Fifth Amendment takings of a commercial asset, which under Title 15, Section 1122, hey, guess what? They lose immunity. Title 15, Section 1122 does not abrogate the 11th Amendment, even though the statute says that they waive immunity. But the mere fact that it is a takings does make it a constitutional violation that would shatter their immunity under the Constitution, therefore allowing you to apply a Title 15, Section 1122 statute. It's all a tort claim. So what else am I saying? Maybe the stuff I haven't said. Let me go ahead and say that. What I'm basically telling you is this. The takings clause, along with other statutory remedies for intellectual property rights, can be applied to a state official and actor. If you would like a case to study on it, you need to study Seminole Tribe. Okay? The public use and eminent domain of certain intellectual property does and has been able to sustain lack of liability. I'm going to say that again. Certain intellectual property has been able to sustain a lack of liability. You know what? That's not even good. Let me take that off. How about this? Judges have been able to maintain their sovereign immunity against certain claims and were not held liable for certain distinct types of intellectual property. The only intellectual property that you have absolute power to go after government officials at all times, up to bogus amounts of sums of money that are codified in statute, is the trademark. That means trade secrets, trade dresses, copyrights, patents. Those do not have the same type of protections as a trademark. Trademark is the outstanding intellectual property that gives you fire superiority under the takings clause of the Constitution and under other intellectual property statutes which label sums of money. Which intellectual property statute for trademark can be used as an example so that anyone listening to this can see how much money they can get? The statute would be Title 15, United States Code, Section 1117. If your trademark is in a trust, your trust can make a lot of viable claims towards contracts and things that you might have going on in order to leverage your signature outside of that contract, because it is similar to the trademark and the trademark can ask about it. And because it's no longer yours and your trust is not an obligated party, it can look into its claims. Whoever has the contract will never be able to express in the court that the trust is liable, but the trust will be able to show a positive control over the trademark. And with that being said, that leads me back to my signature video. That last video that I did about the signature, man, some people in the comment section were going absolutely berserk. I like it. I can't answer all of them because then I'd be on a tangent forever in the back and forth. If someone has, I don't know, a dispute against maybe what I said, and they actually think that the signature is credit, do what I did. I showed you where, you fail. Show me where me and the courts fail. Because the only way that what you say would be true is if your name was a trademark. And with that, I conclude today's talk. Okay? Just to give you a little rundown on that table of contents that I showed you at the beginning of the video, you can see all of the different types of claims and how extensive this document is. Matter of fact, before I go, B. When is infringement of intellectual property a Fifth Amendment taking? 864. Oh, wait, hold on. You see number 3 where it says 15 U.S.C. section 1122? No shit. So it's even in the footnotes. Let's go to 864. Jesus. 857. It's almost coming up. Three more pages. 2, 1. It's even given the claims in the footnotes of how to draft the documents. You see that? It goes into explaining different cases that can get you compensation when a takings has occurred. And I'm going to leave it there. Okay? Bottom line is, intellectual property, the takings clause of the Constitution, those two things, Title 15, Section 1122, that third thing, that is the power base of how you pierce the veil of government officials. They will be held liable. As long as your name is and can be proven worthy of its classification of a trademark status. There are different ways to go about doing that. I'm not going to talk about it today, but I'd like to see your comments inside of the video. Anybody that wants to join at this time, go ahead, hit me up on Facebook. Link will be in the description box. And I guess make what you want with this. But I put it on the table and I gave you a case to study. You guys have an outstanding evening. And share this shit. Like it. Let's try to get 500 viewers on this video. Matter of fact, if you're viewing this, send it to 2 to 3 people that you know could benefit from this. If you could do that, that'd be awesome. Thank you.